Hello everyone. Welcome to the Get Set Law in the monthly legal school. So we'll be discussing about the important legal affairs from the month of June. Live-in relationship not recognized by law as marriage. So this is one of the important issue which has been brought to the court of law, that whether the live-in relationships have been recognized by the law or not. So, since very long, it has been recognized as a fundamental right under Article 21 that we can select our partner with whom we want to live with. So, this has been the basis has been laid down in the case of Puttaswamy versus Union of India back in 2017, where the right to privacy has been given as a fundamental right. So, right to privacy is also linked with the live-in relationship, that if partners want to stay together, they can stay together. So this is the issue, that the point is that whether the partner should be allowed to live together or not. But sadly, we do not have any legislation so far. So this is the one of the main concern. Now it is important that we need to see whether the legislation is there in the place or not. So far we have not got any legislation, and that's what has been discussed by the Kerala High Court also, that they have recognized that there is no specific legislature right now. And when the two parties decide to live together merely by the virtue of an agreement, can we consider it as a lawful or not? So there are different laws, specifically the Special Marriage Act or any other personal law under which they are taking this step. So that is something bothers. So now the main specific issue of the live-in relationship is that we cannot claim a divorce or we cannot claim maintenance. So these are the two specific issues which needs to be addressed. So this is one of the important issue, that marriage is a social institution, and in this institution it must be solemnized by the legislation, right? Because the court is concerned with the ways of the morals, the different ideas with which the morals, the society is drawn, and that needs to be in the picture. So it is very much important that in the country, in the democratic country like India, where the secularism has been followed, it is very much important that we have a proper law in place to uphold this thing. Now, the point is that divorce, as we discussed, that a person cannot claim maintenance or divorce because there is no divorce because there was no legal marriage at place. So the first important aspect of a divorce is that there has to be a legal marriage. And if there is no legal marriage, there is no question of divorce, right? So this is the issue which the court has been dealing with respect to the legislative effect of the live-in relationship. The conclusion is that we do not have any stringent legislation which upholds the live-in relationship. So this is where we are lacking right now, and we hope that in future such kind of legislation might come into the picture. But the major problem lies in the fact that the controlling the situations like divorce and maintenance and adoption, because the no proper marriage has been taken place. So this is one of the issue, and let's see how legislation or how our parliament drives into it and make a proper codified law. We'll move to the next. Tobacco laws in India. Now, this is one of the major concerning areas. So we need to have a very stringent tobacco law. So recently, we have seen the statistics, that is 267 million tobacco smokers. And with this, we are in the second rank of the highest number of tobacco users. Now, the concern is that with the growing age, we see that the people of the age of 15 to 30 are using it more. And this is the most productive age, and that is why we are seeing that multiple health concerns have been grew. So the reference has been taken from the United States Food and Drug Administration. They conducted this research, that what are the impact of different kinds of advertisements of this tobacco. So they have come up that the impact of graphic health warnings have a much more impact. And they made that across the world, it should be made the rule that the graphic warnings in the packets of the cigarettes or the tobacco must be given, so that it will create some kind of terrific effect upon the consumer and they will not consume it. But sadly, this has not been the case. Even after the 80% of the packaging of a tobacco product is covered by the mal effects of the consuming tobacco, but still it has been found that the growth in the sale or purchase or manufacturing has been increasing. So this is one of the concerning areas where we are not able to prevent the smoking, and even we are not of any help for the smokers who want to quit, for the tobacco consumers who want to quit. So we got this specific legislation. The name of legislation is Cigarettes and Other Tobacco Products Act 2003, COTPA. So then thereafter we got this prohibition of advertisement and regulation of trade and commerce, manufacture, supply and distribution in 2004. Section 7 of this act specifies restriction on trade and commerce. In fact, in production and supply also. And later on, they added the restriction in the distribution of cigarettes and the other tobacco products. So even though putting some legislative restrictions upon this particular distribution, production, and manufacturing, they have tried to ban the use, but we have seen that under the right to choice, people have been taking it under a choice. So they say, they claim that it is a matter of choice and that is why they want to consume it. But we learn from the different countries, like we see in the Canada, the health policy of the state of Canada is just amazing, and the other countries need to learn from it. Whereas we see that in our country, the health, if you see the GDP contribution of health is very, very low. The budget allocation in the health sector is very, very low. It is in the COVID where some increment has been seen in the allocation of budget specifically towards the health sector. Otherwise, we were not even contributing 1% of the GDP. So that is why it is very, very important that it is a high time where we are seeing that multiple people are getting a lot of diseases related to the liver, kidney, brain, specifically in the age of 15 to 35. So it is important that now we take this step, now we implement much more stringent law and we try to create awareness in the society which will help us to counter this specific issue. Section 8 also says that at least one of the largest panel of the box containing these products have the necessary warning. So we have seen that how we, as I mentioned, that the 80% of the packaging of the product is filled with the warnings. Then section 9 and 10 of the act describe that how warnings should be delivered. And if for the first time a person violates it, they have to spend 2 years in prison and there will be fine of 5,000 rupees. And if it happens again, it will lead to the 10,000 fine and the imprisonment of 5 years. So that is why strict liability has been kept upon the people who are manufacturing, people who are selling it. So that is why this kind of rules have been put upon. Thereafter, we had World Environment Day on June 5, and this is a day which signifies a remarkable journey on the progression of environment, that how we have treated our environment in the last decade or in the last century. So it is worth noting that every year we celebrate this day, but every year, day by day, our consciousness is getting reduced towards saving environment, because we see that even with the emergence of this climate change issue, and people are still less aware, people are still putting less efforts to save the environment. So this is one of the issue. In this slide today, we'll be discussing the glorious judgments of the Supreme Court, which tried to put a massive impact on the people who are trying to curb the environment. So on the World Environment Day, we'll be discussing the three most important landmark judgments of our Supreme Court, who has tried to establish the environment at a proper place. Also, it is important to note that Article 21 of the Indian Constitution again gives the right that we have a right to clean environment, we have a right to pure environment. Even in the time of COVID, the Supreme Court added the right to have an oxygen. So this is important to note that how environmental concerns has took over in this recent time. Multiple international conferences have been inculcating different new principles, new theories in order to save the environment, right? So implantation of trees, cleaning the rivers. So different steps have been taken in order to provide the and protect the environment. So we will see the first case is MC Mehta versus Union of India. This was famously known as Kanpur Tanneries Act 1987 case. Now, Kanpur Tanneries case was famous because the Ganga River, which is flowing in the Uttar Pradesh area. So it has been seen that the Kanpur Tanneries, so the Kanpur has a huge belt of industries who are discharging the pollutants into the river. So these pollutants are highly toxic in nature, and this will not gonna help. This will not gonna protect the environment in any way. So that is why this was the major concern that have been rose at that point of time, and multiple investigations have been took and reports, survey reports showed that Ganga is serving one third of the India's population. And this Ganga, who is serving one third of the Indian population, is polluted by the discharge of municipal sewage and industrial effluent. So all of this effluents and the sewage which is coming into the river, it is doing or creating a pollution in the river. So this was one of the concern. Now Supreme Court said that Parliament and the government should take this concern into the notice that they need to create a solution. They need to put up the some control measures, because if this will go on, it will completely finish the river Ganga, right? Finish the river Ganga, as in that will not be able to utilize it for our benefit. So that was the concern which was raised by the Supreme Court. Now, Supreme Court also noted that no law authority so far have been succeed in order to remove the pollutants, right? So why it is not possible? Because one of the major element of this mission is the cooperation of people. So state and citizens both should come forward, both should make a pledge that they need to clean the government, because it is not the responsibility of the government alone, but citizens should also take it forward. So this is how the cleaning of Ganga came into the picture, and with the judgments, it will be coming forward. Vellore Citizens Welfare Forum versus Union of India 1996. The Supreme Court held that some of the salient principles of the sustainable development as culled out from the Brundtland report. So it was a very famous time where the Brundtland report came in 1987, and along with certain other international documents like Montreal Convention, Vienna Convention, and in 1992 we had this very famous Rio Declaration. So these were all of the international documents which tried to highlight the environmental issues and the principles such as intergenerational equity, use and conservation of natural resources, environmental protection, precautionary principle. All of these significant principles have been chalked out by this convention and the treaties, and they tried to put up the obligation over the government that they need to take this forward. So even Article 51 of the Indian Constitution says that India will adopt the international agreements and treaties into the domestic laws, and they will make laws accordingly. So it is worth noting that the international law, the treaties, the obligations are not binding upon a country unless and until the country signs the treaty and ratifies in their own country. So this power has been given to our Indian Constitution under Article 51 and Article 253. And specifically with this case, Vellore Citizen Welfare Forum case, the Supreme Court said that all of those principles which have been given in the international agreements and treaties the government is bound to accept considering the deteriorating situation of our environment. So this was a very important case which helped us in order to protect the environment in a much better structured way. So previous we saw that there was just an issue which was not yet structured. The issue has been highlighted, but with this judgment, certain type of structure has been created by the court. MC Mehta versus Union of India. This was a Taj trapezium case. So Taj trapezium case was with respect to the Taj Mahal. That Taj Mahal is one of the seven wonders of the world situated in India, and this is a very significant place, but due to the different polluted industries which is in and around Taj Mahal, it is curbing the beauty of the Taj Mahal. So it was very important that such important heritage of our country needs to be protected. And in order to protect that, in order to stop the environmental pollution happening in and around the Taj Mahal, the court ordered that specifically coal industries need to be shut down or certain emitting rules need to be put up by the government so that the kind of emittance which is happening now from these industries will be reduced. So this is very significant that Taj Mahal needs to be protected. So these were the important judgments from the line of environment law which our Supreme Court has reignited. Supreme Court upholds the BCI rule mandating law degree from recognized institute for enrollment as advocate. So this is one of the issue which existed that the universities which are not enrolled, which are not recognized by the Bar Council of India, if I possess a degree from that specific institute, will I be able to get the license for practicing in the court? So there is this general rule where a person, unless and until has got the license from the Bar Council of India, cannot appear in the court of law and cannot fight before the court of law. So this is one of the very specific provision which says that every advocate must have a license which is under the Advocates Act 1961. Now, this issue was raised in the Supreme Court whether person from the university who has obtained the degree of law, but the university is not recognized by the Bar Council of India, can we bar them from not appearing to the court of law? So this was the question which was raised in the Supreme Court. So court said that yes, it is important because Bar Council of India is the regulatory authority of the law and they can decide the recognition of university because it is very important that the BCI looks over the specific issue, finds the whether the syllabus, whether the curriculum is in line or not. So considering all of this issue, Supreme Court said that BCI was right in putting up this rule that they have the proper power to define this thing. I'm sorry. So it has been held under section 49, which was read with section 24 of the Advocates Act of 1961. So this act together gives power to the Bar Council of India that they can prescribe the norms. Various norms can be decided by the Bar Council for entitlements to be enrolled as an advocate. On the parallel lines, we can see that the power has been given to the Medical Council of India also. Under the Medical Council Act, this power has been given to the Medical Council of India and the Dentist Council of India to provide the license to the doctors and the dentists. So it is right because such regulatory authorities have been created to check whether the skills have been matched or not, whether the curriculum of the university is correct or not. And upon that basis, the BCI gave the recognition to any such university. So this was upheld by the Supreme Court. Supreme Court declines urgent listing of plea against the Manipur internet ban. So an indefinite ban has been imposed in Manipur. So we all know that a clash is going on between the two communities in Manipur. And because of that, an indefinite internet ban has been imposed. So now we will discuss that what is the relevance of internet ban. Internet ban is considered to be one of the fundamental rights under Article 19(1)(a), which says that every citizen of our country has a freedom of speech and expression. Notingly, so this has been previously noted in the Anuradha Bhasin versus Union of India, where a similar situation has been noticed when the Article 370 has been abolished. And again, an indefinite ban has on the internet has been placed upon by the central government in the state of Jammu and Kashmir. So, in order to counter that, a case has been filed and Supreme Court upheld the plea of the citizens that internet cannot be banned as it is a freedom of speech and expression, and also this is a freedom of trade and profession, because at this point of time we are aware that multiple trades and profession are running on the basis of internet. So if my internet is shut down, I cannot continue my trade and profession. Like we are having a YouTube session right now, if I am under the internet shutdown, how will I maintain my trade and profession? So this was one of the concern that have been raised in the Supreme Court, but Supreme Court declined the urgent listing of this plea. So Supreme Court said that High Court is already looking into the matter and we will not take the urgent listing of this specific issue. Hajj is a religious practice protected by the constitution. So Delhi High Court has recently held that Hajj pilgrimage and the ceremonies associated with it fall within the ambit of religious practice, which is protected by the Constitution of India. Now, Article 26 of the Indian Constitution boldly proclaim that every citizen have a right to practice, profess, or propagate any religion which he or she wants to practice. So now, the Delhi High Court has said that the Hajj pilgrimage or the ceremonies involved are well within the ambit of religious practice, and this religious practice is covered under Article 26 of the Constitution. So, religious freedoms or the religious activities and the sacrifices or the practices are the most cherished right which has been guaranteed and protected under the Constitution of India. So, this is in line with the thoughts that a person's religion shall be kept intact so that he has enough liberty, enough freedom to practice it on a daily basis, because it is something with the attainment of the inner peace and tranquility. So that is why the Delhi High Court held that in this particular case, Hajj will be considered as a religious practice, and all those devotees who want to take the pilgrimage of Hajj, they should not be barred, they should not be taxed unnecessarily, because they are protected under the Article 26 of the Indian Constitution. Illegal detention, again a very prominent issue of the month. So recently Jharkhand High Court has directed the state government to pay 5 lakh rupees fine. Now a man has been unlawfully detained and he had been kept in the custody for the 4 months, and later on it has been found that he was not guilty of the offense. The biggest problem is, I will read the words of the court which have been kept in italic in the slides. Please take a note. The liberty and dignity of the petitioner, which are basic to his human rights, were jeopardized as he was taken into custody, and eventually, despite all the glory of the past, he was compelled to face cynical abhorrence. And this situation invites the public law remedy for grant of compensation for violation of the fundamental right envisaged under Article 21 of the Constitution of India for saving the life command, self-respect, and dignity. So these were the very, very important words quoted by the Jharkhand High Court, and they recognize the rights which have been enshrined under Article 21 of the Constitution, which talks about the personal liberty and the dignity of every individual. In furtherance, it is important to note that in our Article 22 In our Article 22 of the Constitution, it has been said that it is a fundamental right that every individual shall be informed about the crime which the person has committed. So, whenever police is arresting anyone for any offense, they should inform the person about the crime he has committed. This is also found in Section 50, subclause 1 of the CRPC, Criminal Procedure Code, which says that at the time of the arrest, person should be informed about the charges which have been leveled against him. He should be given an opportunity to consult his choice, the advocate of his choice, and take all the legal recourse possible in revenge of this particular act. So this is the responsibility and the obligation upon the police to inform the accused. So this was inculcated in the CRPC by the very famous case of D.K. Basu versus State of West Bengal, with which the Supreme Court placed this responsibility upon the state government. Next, misuse of Section 498A IPC. So, a case has been filed in the Gujarat High Court against an 85-year-old woman for cruelty under Section 498A. Now, what is 498A? 498A is the provision which is against the women to protect them from the cruelty. So, cruelty has been given a very wide connotation. Cruelty can also include physical cruelty or the mental cruelty. The court in this specific case said that at this stage, mention is required to be made that the current scenario in the society is that Section 498 has been rampantly misused by the complainants. All the family members are roped in the complaint only with a view to harass the family members, and the apex court has taken cognizance of such incidents in a number of matters. High Court reminded that the misuse of the 498 has been increased in a very fast pace, and the Supreme Court has already taken cognizance of such issue, stating that misuse is more than a genuine use. So this section says that whoever being the husband or the relative of the husband of a woman, if they subject women to cruelty, shall be punished with the imprisonment for a term which makes into 3 years and shall also be liable for fine. So you will be fined, you will be punished for 3 years without taking the cognizance of the issue. So this is one of the important reasons that we need to bring a proper law with which we can ensure that the cases are not fake. We can ensure that the rights of women are given at a proper pace. In 1983, this section has been added into the IPC by the second amendment of the criminal law. And this 498A was added with the unique goal and the cherished goal that the women shall be protected from the cruelty. Now, the concern is that this offense is cognizable, non-billable, and non-compoundable. That is why the issue is that it should not be misused and should be used for a proper purpose. Because whenever the offense is cognizable and non-billable, person will not get the bail. So if we file a false case in this regard, a person will be unnecessarily troubled. And we have seen in the previous issue that an 85-year-old woman has facing this charge. Imagine the level of the trouble which she will get. And this is a case with the multiple people who are facing the wrong charges against the specific section. So the Jharkhand High Court has tried to remind that the Supreme Court has also said that we should not misuse this provision, like we have seen in the POXO Act, which is the prevention of children from the sexual offenses. Oftentimes it has been misused. So that is why it is very important that we become aware of such issues, and we should not misuse this kind of laws which are made in the favor of particular community. So that is why it's very important that we need to understand the value, the gravity of these areas of these laws, and that's how we'll be able to make a better society. So this was all for today, and I will join you in the next class. Thank you.